call case number 16-61644. People of the state of Michigan versus Stephen Patrick Guzina. The defendant is charged with count 1, homicide, murder, second degree. Count 2, operating while intoxicated, causing death. Count 3, operating while intoxicated, causing serious injury. Count 4, failure to stop at scene of accident when at fault, resulting in death. Count 5, failure to stop at scene of accident resulting in serious impairment or death. Count 6, reckless driving causing death. Count 7, reckless driving causing serious impairment of a body function. Felony with a motor vehicle advisory. This case is scheduled for examination today.
Good morning, Your Honor. Molly Kettler on behalf of the people of the state of Michigan.
May I please support Evan Callahan, P30564 on behalf of the defendant.
All right.
Ms. Adams, can I say something?
No.
Abstain? Okay, I didn't
You
know.
probably want to talk to your attorney.
Okay.
Would you like to speak with them at this time?
Yes.
Okay, we'll take a short recess. While we're doing that, before we get to that, well, we do have the media here today. Does anybody have any concerns in that regard with witnesses?
Yes, Your Honor. My request would be at the time that we proceed to preliminary exam that civilian witnesses not have their faces shown on TV or in the media or in any pictures in the print media.
No objection.
All right. Gentlemen, you have any problems with that? All right, very good. We have an understanding. All right, that being said, let's take a short recess.
Thank you.
And maybe we can call something else in between again, something short. Oh, that's right. But the thing, the issue is, I didn't know, because I'm a 36 court judge, so all my stuff goes over there. It doesn't come over here. We don't have a fax number over here. So, oh really? So you don't need my card with mine? You do?
I'll take it.
Okay. Because that's what they were saying. We think that it went to, or sometimes it goes upstairs. So when you realize that I'm here at Frank Murphy, it'll go upstairs and we won't get it. Yeah, I still won't get it. So a direct thing. So just for future reference.
Thank you.
Thank you.
I'm still looking at
you can have a seat, yeah.
Court closed, case number 16-62192. People of the state of Michigan versus Guzina. Sierra Carter.
Ready?
The defendant is charged with count 1, malicious destruction of personal property, $1,000 or more.
Okay, you want your appearance on the record?
Well, I guess, Your Honor, limited appearance. Kirsten Iverson, P71920.
Just to acknowledge that you are here.
That is correct.
Okay, very well. Preliminary matters?
Yes, Your Honor. I have been advised this morning that Mr. Guzina has hired counsel to replace me. And as a result, I'm requesting the court grant an adjournment. I spoke with Mr. Guzina, and it's also his desire. He wants the attorney that he's retaining now to conduct this exam. And I can understand that. In fact, what I would add is, I don't like doing some case where some other attorneys conducted the exam. I've got my own way of doing things, and I appreciate and respect the fact that Mr. Guzina desires to have his retained counsel handle this examination. So I'm requesting an adjournment of this exam at this time, and that's
Really make a motion.
and leave to withdraw.
Yeah, I was gonna say, you are
Right
asking
now.
for a motion to withdraw,
Yeah.
and based upon that motion to withdraw, another attorney has been retained or is going to be retained, and so it would make sense that at this time, the attorney probably is not ready to proceed.
That is correct, Your Honor. I was retained approximately 10 o'clock last night. I asked Mr. Guzina for a copy of the discovery so I could review it. He did not have a copy. Clearly, I haven't seen any of the discovery. That's my reason for not filing an appearance at this point, because I would not be ready to proceed.
Okay, but you are at this time, and so the people wanted to say,
Yes, Your Honor. We strenuously object to an adjournment of this preliminary examination for several reasons. One is that this particular defendant has had, since the date of this incident, which was October 29th of this year, to retain an attorney. He was charged on October 31st. The probable cause conference in this matter was over 3 weeks ago, November 11th of this year, and at that point in time, we set the preliminary examination date. While I can certainly appreciate that the defendant wants to have the counsel that he retains, here's the issue. He's had a great deal of time to do this. There was some discussion about a different attorney being retained way back in the beginning, then it was back to Mr. Callahan, and now, lo and behold, he retained somebody at 10 o'clock last night. So, as Mr. Callahan indicated to the court, he did not know of that until this morning, which means he, as a verified attorney, is prepared to proceed. The reason we object is because this is not fair to the victim's family. Mrs. Jarrett, the widow in this family. It's not fair to the partners. It's not fair to the people for the defendant to be able to manipulate these proceedings and cause this to go on further while they're enduring this indescribable torment, especially around the holiday. It's not fair and it's not right, and we object to it. We're prepared to proceed, and we ask the court that we be able to proceed at this point in time. This exam requires a lot of resources. We have at least 6 police officers here, as well as civilian witnesses, and they've been pulled off the street from doing other things they could be working on. Anybody who reads the news knows there's a lot going on in the city right now. We're all here, we're ready to go. His failure to plan should not punish the people and the victim's family in this case, and we're asking the court to order this exam proceed.
Okay, I see the PCC.
anybody want to speak to that?
Your Honor, I just have one brief comment. The only thing I would add to the record is that Mr. Guzina has not actually had an opportunity to prepare for this date. He doesn't have a copy of the discovery. That's very problematic in being able to prepare for the exam and then be able to assist his counsel. For whatever reason, he doesn't have a copy, I don't know. But I would agree with the prosecutor. This is a very serious case, and for him to be able to have to proceed without being prepared for that, I'm concerned that there would be some claims later on of some constitutional issues.
Okay, well, I noticed here that there was, I'd say, a 7-day rule waiver.
Correct.
And that was because what?
I believe, and of course the court can speak and the prosecutor can speak, it's my understanding that it was a prosecutor's request, but I'm not 100% for sure.
That was due to Mr. Callahan, and it's no aspersion on him. He had a heavy trial schedule. We didn't want to push it out as far as it was, but there was no other choice. So they've already had one adjournment to accommodate counsel for the defense, and counsel Iverson indicates that the defendant's not prepared because he doesn't have a copy of his discovery. His counsel of record is prepared to proceed, Mr. Callahan.
Okay.
I'm just not comfortable doing that, given the fact that retained counsel sitting right here.
Well, preliminary exams are so the defense can see, the court can see what people have to move forward. If there's probable cause, is their show. You know, it's their show. And of course, defense counsel can cross-examine the witnesses that they bring forward, and look at some of the evidence they have provided. It's their show. They have the burden. So, Mr. Guzina, what's going on with just getting a counsel at 10 o'clock last night when you knew you had an exam, when the court had already moved this forward? The exam was, well, the probable cause conference was 11/18, and we moved it out this long.
I have been trying to raise the money for over 3 weeks. My best friend, since I've known since 8 years old, decided to help me out. So that's the reason why I've been trying for 3 weeks to get retaining an attorney.
Okay. All right. Now, the attorney that you do have right now that's been assigned to the matter, he did explain to you what the preliminary examination is?
No,
Oh, excuse me.
I don't know. I'm not sure.
I'm not going to let him do that, Judge.
Well, no, I'm
sorry.
not sure exactly what you're asking. Let's put it that way.
Do you understand that the probable cause conference, or should I say the preliminary examination, the people have to establish probable cause for each element of each charge?
Yes.
All right.
I understand that, yes.
I think you know that. I know counsel has been practicing a long time, and he would not have you move forward
I
without
understand.
knowing what that is. Okay.
Since you explained this to me, it makes more sense to me that way.
All right. So, that being said, we're going to move forward with this today. We're all uncomfortable about it, but we have to move forward. It's too many people, too many resources, too many people here. We're going to move forward today.
And we have 10 minutes.
Yeah, by all means.
And just so the record is clear, Your Honor, that I'm not filing my appearance at this particular
You
proceeding.
made that clear.
Thank you.
And it's on the record now.
Thank you.
But if you want to stick around and see what the people have, you know.
If I can just correct for the record, I'm sure Your Honor just misspoke, but I think Your Honor indicated PCC was on the 18th of November. It was the 11th.
Okay, thank you. I appreciate that. Court has no problem. Okay. Go ahead, going. I thought he was holding him down.
I don't know where he went.
Where's he going?
He asked for 10 minutes.
Oh, okay. Yeah, but he put his hat and coat on. Usually people just walk out the door.
I'm in the lobby, so I'm perfect.
You know,
I know
I'm going to look at him out on the porch in the hot day. You can't see anybody turn the awning now. Okay, we're in a short recess. Counsel, do you have a case here today? Why are you here?
Can I approach?
Yeah, I don't want any ex parte issues. And I don't want to get in trouble with your mom.